So, hi and good morning, everyone. We are having our Aging a Family Affair get together, and I'm so delighted to be here with you all. I wish I was there with you in person and we were all together. Hopefully, that will be soon. In the interim time, we are going to learn more than we ever wanted to know about powers of attorney. And I have been honored to provide this presentation a number of times in the past, and we've talked about powers of attorney, but we are going to do a deep dive today. We're going to be talking about all the reasons why you need them, how you get them, what they do, and what happens if you don't have them, right? So get ready to take notes and learn lots of stuff about POAs, powers of attorney. So, how do powers of attorney fit in with the process of getting older and aging? We need to really think about the role that capacity plays in our lives, and it's something that we can easily take for granted. Sometimes we just think that we're going to power on through an illness or power through a diagnosis, and that maybe our life is not going to change that dramatically. But as you well know, reality and our perception don't always align. So really it's important to plan for the time of incapacity, and planning will include the many of the things that I've got here on the screen for you. Planning during your life, right? You're planning for incapacity, you're planning for medical crisis, long-term care, and distribution of your assets at death. So we take a very comprehensive view of planning at my law firm, and we want to talk with you all about and encourage you to do planning for each of these stages in your life. And powers of attorney are going to fit in to these stages, and they're a tool that are going to help you get through a lot of these difficult times. One of the tools that we use to determine what type of planning a client needs is this elder care continuum. The elder care continuum looks at where does the older person live, how are they functioning, are they active and independent, or are they relying on others? Is there a diagnosis or a medical condition that would cause more dependency rather than independence? And so those are also judged by activities of daily living, right? So how much support does someone need in their older years as their age progresses? Are they going to need assistance with bathing and dressing and grooming? Will they need assistance with managing medications, managing money, communicating with others, transportation, and so forth? And we look at where's the person living, how independent or dependent are they, what are their resources, how much money do they have available to assist with bridging the gap where there might be a disconnect between where they're living and their ability to function. And then we can make a suggestion about what kind of planning they might need. So they might need a comprehensive estate plan. That would be for a really active, newly retired person, or a person maybe in their 50s and 60s that's approaching retirement, looking at what they might need. But as your age progresses and your ability to function might decrease, you might need more planning. You might need more supports, and so we would we would add another level of planning in the elder care protection plan and so forth for the life care plan. So I wanted to show you how powers of attorney fit in with these different layers or levels of planning. And you can see that for an estate plan for that older active retiree, the estate plan. You can start with that anytime, and it's always going to contain some of those fundamental core components. And one of those core components is powers of attorney. You can see the second line here. Powers of attorney are going to be a key component of the estate plan. That plan is also going to include a last will, a living will, perhaps trusts, right? And it can also include an annual review with your attorney. But as we age, the need for more intensive planning comes in, and that's maybe as people in their 70s and 80s looking at elder care protection planning, right? So these are aging adults that are planning ahead. They're not in a crisis yet, but they're anticipating, I realize that there are realities in life, and my ability to be completely independent, not rely on others, and 100% healthy is probably going to change. Let's just be realistic. So maybe in the next 3 to 5 years, I'm going to have an increasing need for care and support, maybe from family, maybe assisted living, maybe independent living, right? So, but I still need those core planning tools, and powers of attorney is a key component of that as well, right? So we would have powers of attorney, wills, trusts, need for Medicare counseling, maybe a need for planning for public benefits, maybe for TennCare benefits or veterans benefits, and then someone's potentially to check in with us to see how we're doing on, are there changes in how we're functioning? What's our functional ability? What does that look like? So some type of annual check-in with a care coordinator. And then you can see that as health starts to really decline and care is actually needed, care is needed now, we're moving into the life care plan type of service. And you can see that powers of attorney are a key component of that service as well, along with other estate planning documents that we've discussed, and then actually activating applications for public benefits like Medicaid, TennCare, veterans benefits, and others. And then there's the ongoing care coordination that's such a key component to what we do. So I wanted to bring that to light. So next let's talk about what your legal documents should do for you. Certainly support your care, right? Support your care and financial needs, as well as your benefits needs. So when we're thinking about all the things that might need to be done, and that would be on the prior slide. Remember, all these things that might need to be done, your power of attorney is one tool that we use to help accomplish all these other things. So you can see how important it is, right? So that's what we mean by benefits needs. We want the power of attorney to be effective for helping us do things that need to be done in order to apply for benefits, in order to get benefits, in order to maintain benefits, and in order to protect and preserve assets to the extent that we reasonably can. That would be for the benefit of the person we're planning for and their family. So we also want comprehensive documents. So we don't want bare bones documents that are very simple but don't do as much as they need to do. I would err on the side of having a more complex, more comprehensive, complete document that deals with everything that you can imagine needs to be addressed, all in one place. So that when the time comes, who knows what the issue is going to be in the future that might complicate your life. If you've got a really wonderful comprehensive planning tool, it's much less likely that you're going to need to redo those documents in the middle of a crisis. You're going to have the tool you need. That's going to be one worry off your list, and you're going to say, I'm so glad I did it right. Those documents should also be customized for you. And so whenever you're working on drafting these important legal documents, remember the relationship you have with your attorney is very important, and it's built on trust. What we're trying to do is accomplish for you what your goals are and have things work for you the way that they should. So these documents are not one size fits all. There may be things that you feel uncomfortable about in your documents that you just don't want your agent to have the authority to do. You can take those parts out. Or there may be areas where we just want to build in a few other safeguards for you to feel comfortable. But just remember that that they can be customized. It is okay to edit and to take something out or put something in. Just do it with the guidance of your attorney. Likewise, they should reflect your unique needs, your circumstances. If you have a blended family, it needs to address the fact that maybe your agent is a stepchild, right, instead of your birth child, or maybe it's your stepmother or stepfather that you're assisting. So, they can all be customized for those specific life circumstances because you're unique, and your documents should be unique just like you are. If you choose an off-the-shelf template that is not customized for you, and you don't work with an attorney to make sure that it fits your circumstances, the caveat there, the warning that I often give is just realize that when you really need it to work, when you're in that crisis or on the cusp of that crisis, you may be disappointed because it may not end up doing all that you want it to do. And that's where, just having it's not enough. You've got to have it, and it's got to be right. It's got to be prepared properly. It's got to be signed and executed properly, and so forth. So what should your basic estate plan include? I've already touched on this on one of the first slides, but you see that powers of attorney for property and power of healthcare power of attorney dealing with personal issues are the very top of the list. And that's because, in my opinion, they're more important than everything else. If you only have 2 documents prepared as part of your overall estate plan, these are the 2 that I would recommend and that I would choose for myself. Especially if I have a really wonderful durable general power of attorney, I can use that document to accomplish so many of the other things that need to be done. I can use it to create trusts. I can use it to change beneficiary designations on life insurance or retirement plans or bank accounts. I can use it to change the deed to my property, right? So there's so many ways that I can do that. I can use that power of attorney, in essence, to do a lot of estate planning that's just not a last will and testament, right? But it could be all these other types of planning. And those can be very, very effective, and sometimes they can be simpler than a last will and then a probate administration. So I can't underscore enough that having these and having them done well and done properly is perhaps the most important step that you could take in trying to get your affairs in order, and also trying to make things easier on the people that you're going to rely on to assist you, right? If you're going to ask them to do these things for you, to assist you, then give them the tools to do it with. One of the other things that I see oftentimes happen with folks is that they have a great estate plan, but they don't know how it works. They don't understand their plan, and that they're not really doing the follow through that's needed for their plan to work properly. I see this with trusts quite a bit, is that there will be a wonderful trust that's been drafted, but the property belonging to the trust maker is not inside the trust. It's never been moved over. And so that trust is really just sitting there like an empty vessel, an empty container, and it doesn't have any property in it. So it doesn't control anything, and therefore it doesn't do anything for the client. So, making sure that the person understands their estate plan and how their assets and things work together is a very important part. That's why we look at how things are titled and how beneficiary designations and things like that are set up, because it all has to work together. So now we're going to start our really deep dive into powers of attorney. Let's start with some definitions so that while we're talking about this today, we're all on the same page about what things mean. Principal with a PAL right, is the person who grants the power to another person. So if this document said durable power of attorney for Amelia Crotwell, then I'm the principal, right? Because I'm the person that's granting powers to another person. And the person that I grant those powers to is called my attorney in fact. Attorney in fact. And sometimes people refer to that person as an agent. And they're both correct, right? Neither one is wrong. They're both correct. I tend to use attorney in fact for the person that does all the money stuff. And I tend to use agent for the person that ends up doing all the healthcare and personal stuff. But you'll see, depending on who's drafting the documents for you, you'll see those used kind of interchangeably. Then there's also oftentimes a reference to a fiduciary. And a person that's serving as attorney in fact or an agent is also a fiduciary. So a fiduciary is a category of people who occupy a position of trust, and therefore they're potentially in charge of decisions for another person or in charge of assets for another person. And they have to do that in a very careful manner, right? They have to make sure that they don't run afoul of any conflicts of interest. They have to be careful that they do things that are in the best interest of the other person. They're not self-interested to the fiduciary, him or herself, right? They're kind of above board. So it's really a person that's doing their very, very best on behalf of another person. Durable, we use the term durable a lot in front of power of attorney. And the term durable means that the document itself has a paragraph in it. And that paragraph says that the powers of the attorney in fact continue, right, exist even if the principal does not have capacity anymore. So if the principal has become incapacitated, maybe due to a stroke, right, or a fall or a surgery, or for whatever reason, the principal is no longer able to communicate or to make a decision, then the document continues to work, it continues to be effective. The attorney in fact still has all those powers that they had before, because there's a paragraph in there that says, it is my intent as the principal that this document continue in full force and effect, even if I become incapacitated or disabled. And our statute requires that specific language to be included in the document. So having the title durable power of attorney at the top of the page doesn't make it durable. The thing that makes it durable is that paragraph, that statement within the document, that statement of intent on the part of the principal that the document will continue to have effectiveness even if the principal becomes incapacitated or disabled. What is a springing power of attorney? A springing power of attorney is a power of attorney that is not effective when it's signed, but is effective at a later date and time when something else happens that springs the power of attorney into action, right? So you can think of it as a power of attorney that's a tool that's kind of set aside and is just going to sit there and wait for there to be a need arise. And when the need arises, if that's one of the springing events, then the attorney in fact will be able to have the powers at that time when they need them. But in that interim period, when there's no springing event, the power of attorney is not effective. So these were very, very popular 10 years ago. I see fewer and fewer of these springing powers today, and I don't recommend them, and I rarely do them for my clients. And I think one of the reasons is because it's very difficult to get the information that you need to spring it when you need to spring it. And so why set into place more difficulties for yourself? If you just make it immediately effective, then it can be used when it needs to be used. And if you have a really trustworthy person that you've named, then they're not going to use it if they shouldn't be using it. And that makes things quite a bit simpler. And then when we're talking about a durable power of attorney, a durable general power of attorney, the term general typically refers to property matters, financial matters, or legal matters. And it's sort of most anything the principal, him or herself, could do, the agent can do as well. Of course, you always have to look at the language of the document to see, is this broad, is this tailored, is this limited, right? Healthcare, we're talking about all things personal, not necessarily limited to medical, right? That's a very important distinction. Healthcare doesn't necessarily mean only medical. It can be all things personal. So if we have an elder living at home, their healthcare agent might be helping them with grocery shopping, laundry, paying, taking the utility payment to the utility company, or picking up prescription at the drugstore, or taking the dog to the vet. It could be all those different kinds of things might fall under healthcare. And you can see that sometimes there's a little bit of overlap. So a healthcare agent might also be doing something that incurs a cost, like picking up a prescription. And that's where typically then the attorney in fact under the durable general power of attorney is going to reimburse the healthcare agent if they're not one and the same person. Okay, those are some of our definitions. What do powers of attorney do, right? So the principal is giving the attorney in fact or agent the power to act on behalf of the principal, even if the principal cannot do the act him or herself. I've already talked about this in terms of durability, but really that's the goal of having a power of attorney, isn't it? We want to make sure that if we are not functioning as an older adult or as an adult, an aging adult, if we're not functioning well, we don't want things to disintegrate around us. We want to have tools in place so that we can continue to perhaps live at home, or perhaps have as much independence as possible, and our lives, don't become too chaotic, right? We can maintain some of our habits and our schedules and quality of life, and maintain some levels of independence with support from others. And the power of attorney is a tool that we can use to help support those kinds of situations. I've had clients say to me before, well, I don't want to sign a power of attorney because I don't want to give up my right to do those things myself. I want to be able to do those transactions, to do my shopping, to pay my bills. And my response is always, hey, powers of attorney don't take anything away from you. And they don't. It does not remove the right or power from the principal to continue to conduct his or her own affairs. They can still do all those same things. Nothing is lost. Nothing's been removed. You're not deprived of any power or any right or any autonomy. You just have some supports in place in the event that you need them. A power of attorney can be revoked. So if you have powers of attorney in place and you're not happy with the people that you named, or your relationship changes, or your circumstances change, and it's no longer practical for the person that you named to serve in that role, then you can change that. You just have to have capacity to do so. And that means you have to understand that you want to make a change, that you understand the consequences of making that change, and you're able to communicate that in a rational manner to your attorney so that they can update your paperwork for you. Powers of attorney can be broad or they can be limited. And sometimes we'll do a limited power of attorney to one family member who's going to offer one form of support. It may be a broader power of attorney to another family member that's going to offer a different level of support. It's okay to have more than one as long as they don't conflict. It's okay to have them broad or to have them limited to specific types of actions. And powers of attorney are pretty affordable. So when you think about all of the things that could happen as you age, that could be difficult and costly situations, scams and all kinds of things nowadays. When you think about the benefit you get from having terrific powers of attorney versus the cost, it's a no-brainer to go and get these done. So don't delay. Go and spend, and be prepared to invest somewhere between, I would say, $500 and $1,200 for a really nice set of these kinds of papers from an attorney. So what if you don't have powers of attorney and you should have had powers of attorney? What is going to happen in that event? So let's say you have no powers of attorney in place, and our elder client has no capacity to make a new one, right? So maybe they've had a stroke and they can't communicate, and we cannot verify that they have the ability to make decisions or even choose their attorney in fact at this point. And we still need to make all these decisions. We still need to make financial decisions. We need to make healthcare decisions. We need to know what to do with the dog. We need to know what to do with the house. We've got bills to pay. We've got insurance issues. We've got all kinds of things coming at us. And we don't have any tools to do anything to go and handle these things. So what are we going to do? We're going to have to go to court and get a judge to put in place something called conservatorship. And conservatorship is, it starts with a lawsuit against the person that is no longer has capacity, right? So it's where typically, a child might end up suing a parent in court, and the court removes the right from the parent to make their own decisions and place that decision-making authority in the child, and then the court directs and supervises that child in the conduct of business affairs or health or medical decisions for the parent. So talk about having some external pressures on the whole family group and just trying to take care of a parent. Then all of a sudden you've got a whole court system involved, and the court system telling you, how to proceed, what you can do, what you cannot do, and so forth. It can be expensive. Takes a lot of money to hire attorneys to do that, and there's more than one attorney involved. There's court costs. Sometimes most of the time you have to post a bond. That costs money. And then every time the conservator wants to make a decision to, for example, sell a home or reinvest some property, you have to go to court and get permission for that. And every time you do, that costs more money. And then there's an annual accounting to the court, which can be time consuming, and you have to produce every invoice and every check for the court to review. So they're going to look at every transaction that flows through the hands of the conservator every year, and you have to account for that. And if you can't account for it, then the court can hold the conservator liable for that. So it is, in my opinion, a process to be avoided if you can safely avoid it. And having a power of attorney and healthcare power of attorney is a great way to avoid having to get a conservatorship. And it also allows you, as the person making the power of attorney as the principal, it allows you to set the scope of what your attorney in fact is going to be able to do for you, number one, and who that person's going to be. And that gives you the ability to control your future in large part. So why leave that to a judge that doesn't know you, has never met you? Why let them make those decisions? Okay. How do you get powers of attorney? You go see an elder care or estate planning attorney and get those done. And the attorney decides if the principal has the ability to sign the document. And they may want to see medical records. They may refer you out for an evaluation with a neuropsychologist. But important for you to know, even if there's a diagnosis of dementia or diagnosis of Alzheimer's or something similar, that does not mean that there cannot be a power of attorney. So let me say that another way. Just because someone has dementia or Alzheimer's disease, they can still do a power of attorney if they have capacity. And that would be determined by the attorney preparing the document. So if you're not sure, find out, inquire, go have a consultation, and then you won't wonder, and you won't have to default over to conservatorship at a later point. So when the attorney is making a decision about capacity, they're looking to see, does the principal understand in a reasonable manner the nature and consequences of the act of giving a power of attorney? So they definitely need to know who they are. They need to know who the attorney in fact is, right? They need to know that the agent is going to be trustworthy and capable and is going to do a good job for them. Sometimes you try to be consistent to see, is this going to be the same person that they may have appointed many years ago in a prior document? What role does that agent or attorney in fact play in their life? That's capacity to contract, understanding the nature and consequences of the act itself. What types of powers should a comprehensive power of attorney contain? Well, anything and everything the principal can do for him or herself ought to be reflected somewhere in the four corners of that document. So the ability to name successors, to ask for accountings, definitely want to make sure that it allows for the handling of retirement plans and gifting, changing rights of survivorship, designations, changing beneficiary designations on life insurance and other types of assets. This is a big one, creating and funding all kinds of trusts. You definitely want that to be included in there. Handling online accounts, digital assets. A lot of things are moving digital now. You want to make sure that digital matter is included in the document. The ability to do planning for Medicaid or veterans benefits or estate planning, right? The ability to give assets to others that they want to take care of. Maybe a parent has a disabled child they want to take care of. You want that addressed in the document. The ability to resign from fiduciary positions, and then spousal agreements, right, including separation or divorce. If you've got to have a springing power of attorney, you want to have a release included in the paperwork that says that any physician that's been asked to provide a medical opinion about capacity in order to spring the power of attorney, that the physician has permission to do that, or else you're just caught in like a catch-22 where the physician won't give you the information and the power of attorney won't work until you get the information, and you just get caught in this terrible loop. You want to avoid that. So healthcare powers of attorney are slightly different from durable general powers of attorney in that they deal mostly with personal and medical care decisions and less with finances. So when you nominate an agent under a durable power of attorney, you're nominating someone to make healthcare decisions for you. And typically that's if you're unable to make those decisions or speak those decisions yourself. You could say even beyond speaking, you could even be communicate, because if you could communicate by, for example, blinking your eyes and you were able to listen and thoroughly understand all the aspects of a decision, you could likely still communicate that decision. And the medical community is going to default to letting the patient make their own decisions as long as possible, as long as it's reasonable. And so we don't see many springing healthcare powers of attorney. The document also provides some instruction to your agent on your preferences about care and caregiving and where you receive your care. And so the agent then has more of a guide in making good long-term decisions for you. What should a comprehensive healthcare power of attorney contain? In the state of Tennessee, it has to include this warning to a person executing this document. And this is a full page of warnings that basically tells the person that this is an important legal document. You should read it thoroughly before you sign it. It gives the person the ability to make healthcare and medical decisions for you. It also gives them the ability to handle the disposition of your remains, your burial and funeral, organ donation, and authorize an autopsy for you, that you can revoke it at any time. So it's an important warning. We include that in our paperwork. It needs to be HIPAA compliant because HIPAA is our federal privacy law that governs the disclosure of healthcare and health-related information, and needs to absolutely meet those requirements or it's not going to work. I would suggest that you have a number of people as decision makers in the list, a tiered list of maybe 1, 2, 3, 4. If you have 4 wonderful and talented children to be your decision makers, list all of them and list the one first that's the best decision maker, that most is inclined for that role, not necessarily the oldest first. So you want someone in there that's going to be a really good advocate for you, ask good hard questions, and stand up for you if you're in a healthcare situation. This person, and when you do a comprehensive healthcare power of attorney, you're also going to address things like life support, tube feeding, IV feeding, discontinuance of medical devices like pacemakers and those kinds of devices. You can designate your primary care physician so people know where you've been going and who you've been seeing. If you are a woman of childbearing age, you want to address pregnancy. If you were to become incapacitated during pregnancy, you would probably want life support to continue until that child could be delivered. So those provisions are typically in powers of attorney for women of childbearing age. And then there's a reference to any additional instructions that might be available to your healthcare agent. In our office, we do the Your Way book. I've seen 5 wishes quite often. Then there's also living wills and advanced care plans that can really help fill in some of the gaps where the healthcare agent doesn't have quite as much knowledge about what you might personally have wanted, and they can make better decisions with you when they have more information. It's also a good place to address any religious or spiritual preferences that you might have. Some of my clients might be of the Jehovah Witness faith, and if so, they would not want a blood transfusion ever. So that would be something we would call out in their healthcare power of attorney to make sure that they are never subjected to a blood transfusion. So if there are religious preferences, that's a good place to include that information. The healthcare power of attorney can also include information about psychiatric treatment, organ donation, disposition of remains, and autopsy, which I mentioned earlier. You can say that if a conservator has to be named for you, who that should be, who you choose that to be. You can release third parties from liability if they rely on your agent. That might make a third party, a medical provider, a little more inclined to provide the treatment or not provide the treatment that your healthcare agent is advocating for. And they give enforcement powers. So if the healthcare agent wants to do a certain type of treatment or known treatment for the principal, and the healthcare provider says, no, we're not going to do that, then give the agent the ability to either go to court and get a court order, or the ability to transfer you as the principal to another medical provider that will respect your wishes. I often think that having compensation in there for the healthcare agent is a good idea. It takes an awful lot of time, energy, and attention to be a good healthcare agent, and it'd be nice to be paid for that if there's money there for that. Amendment and revocation terms, of course, are part of this power of attorney as well. Okay, common misperceptions about durable powers of attorney. Oh, I have one, they're all the same. That's not true, right? They're not all the same. They're very, very different, and it really depends on what language is included in that document. They're not all durable. Remember, you've got to have that paragraph in there that says, I intend for this to withstand my incapacity or disability. So just because it says durable doesn't mean it's durable. And that they all grant the principal the ability to do whatever the principal wants to do. That's not true either, right? You can't do just whatever you want to do. You have to do what the document allows you to do, and then you have to make those decisions in the best interest of the principal. It does not prevent the principal from acting. It doesn't take anything away from the principal. The principal can still do how he or she pleases. And so sometimes it's not restrictive enough, right? Some people think, well, I'm married, so I don't need one. My husband or my wife can sign for me if needed. That's not true. That's not true. So the only way that a husband or wife can sign for their spouse is as it pertains to non-real estate joint assets. That's the only thing. So that is not a reason, an excuse not to get a power of attorney. You still need a power of attorney if you're married. It is important to note that the power of attorney does not remain effective after death. It does end at death, except for the ability to make disposition of remains arrangements post-death under the healthcare power of attorney. And then that any adult can sign one at any time, or that Alzheimer's disease or any kind of other kind of diagnosis might prevent getting a power of attorney. So you have to have capacity. And if you have capacity, as an attorney might determine that, then it doesn't matter what your diagnosis is, right? You can sign one. And even if you don't have a diagnosis, but if you don't have capacity, you can't sign one. It's really a capacity inquiry, not a disease or diagnosis specific inquiry. Pitfalls concerning powers of attorney. The biggest one I see, not having one when you need it. So you have to have them before the crisis happens. If you don't have them yet, please go get them. And if you have them already, take a really good hard look at them to be sure that they're going to do all the things that I've suggested would be helpful in this presentation. If you have them, that you did them yourself, or you copied them from a friend, or you got them off the internet, be very careful. They may or may not work when you need them to. Why would you put something so important in a situation where you're not being careful about how it's being prepared? So be very, very careful and err on the side of being conservative here and making the investment in something that's really going to work for you. I see people that don't execute them properly. They're not notarized properly. They're not witnessed properly. They don't read them. Don't know what they contain. They just think, well, it's a power of attorney. You can go do whatever you need to do, and then they learn they can't. You can always record them in the original county's office where you reside, like where the principal resides, and that's notice to the world that the attorney in fact has been appointed and may be acting. Other pitfalls: not being able to spring one that needs to be sprung because we can't get the necessary medical information from the physician. Improper choice of attorney in fact or agent. So if you nominate someone to be in that position, and then they turn out not to be trustworthy, and they're stealing from you or taking advantage or exploiting, then that's a pitfall. You really need to name people that are beyond reproach when it comes to being honorable and trustworthy. And then oftentimes we see, well, maybe powers of attorney have been in place for a long time, and right now sister has power of attorney, but brother's not happy with the way sister's been doing things, and so brother takes mom to an attorney and has a power of attorney drawn up in favor of brother, and now we have two, and which one is the one that's the real one? And unfortunately, in those circumstances, oftentimes what happens is we end up having to go conservatorship route, getting the court involved to help resolve any disputes about which power of attorney is the power of attorney that we should be honoring. So I think I'm about out of time. I'm going to turn it back over for questions, which I think come next. Thank you very much for letting me make this presentation. I've enjoyed it very much.